Financial conditions of release, often known as money bail or bond, are probably more commonly used than any other pretrial release condition. They also have a profound impact on justice-involved people and on the system overall. The use of money in pretrial release decisions is one of the key drivers of the litigation, legislation, and local policy reform that is occurring throughout the nation. Most jurisdictions default to the use of money for a large portion of the arrested population. But is this an effective practice? Let's take a look at the legal principles behind the use of financial conditions, as well as what the research tells us about whether these conditions actually work to improve pretrial outcomes. There are three main legal principles governing the use of money bail. First, financial conditions of release are exactly what the name says, conditions of release. So what that means, and what courts have repeatedly held, is that money bail cannot be used to intentionally detain someone pre-trial. Most states allow for preventive detention, that is, intentional detention, of certain people before trial. But these states typically put strict limitations on who may be detained, and they provide those people with due process protections. A court cannot simply get around those requirements by setting financial conditions at an amount it knows the person will not be able to meet. After all, that practice would effectively allow the court to detain anyone, regardless of what the law says. Second, if someone remains in jail simply because they can't afford to post a money bond, that use of money will be subject to heightened scrutiny on appeal. So the first principle we just discussed says that a judge can't intentionally detain someone through the use of financial conditions. The second principle says that regardless of what the judge intended, if someone is stuck in jail because they can't afford a bond, appellate courts are going to take a really close look at that. And in many cases, they won't allow it. This principle emerges from a recent stream of federal and state cases finding that pretrial detention on the basis of someone's inability to pay a money bond is a violation of due process, of equal protection, or of both. The Supreme Court hasn't yet taken up this issue, and the reasoning in lower court decisions has varied a bit. But the bottom line is clear. Courts are increasingly holding that it is rarely, if ever, permissible to keep someone in jail because they cannot afford a bond. As a result, many jurisdictions have decided they need to substantially reduce, and in many cases eliminate altogether, the use of financial conditions. The third legal principle governing financial conditions of release is that a court must assess a person's ability to pay. Again, this is a principle that has not yet been universally held across the country, but many court decisions are moving in this direction. And fundamentally, it makes sense. $500 to one person might be a nuisance, but pretty easy to come up with, especially if it means getting out of jail. And to another, $500 might as well be $500,000 because they have no hope of scraping that amount together. So what does this mean practically? One, it means that using charge-based bond schedules, where everyone with the same charge presumptively gets the same financial condition, is just not sustainable anymore and is possibly unconstitutional. And two, that a judge needs to figure out for each individual whether a financial condition is actually necessary to reasonably assure a person's appearance in court and safe behavior. And if so, how much money would suffice given that person's ability to pay? But even those questions are premised on the idea that financial conditions of release work. That money somehow ensures that released people, one, return to court, and two, don't endanger community safety. But is either of those things true? Let's look at what the research tells us about the effectiveness of financial conditions. So first, financial conditions originated as a way to make sure someone returned to court after they were released pre-trial. The idea being that you or someone close to you needed to have money on the line that would be lost if you didn't show up. So if this theory were true, You would expect that people who had to post money in order to be released would show up to court at higher rates. Is this what happens in practice? In short, no. In 2017, in a nearly 200-page decision, after weeks of hearing evidence, expert testimony, and reviewing the existing research, a federal district court in Houston, Texas concluded that, quote, the reliable, credible evidence in the record from other jurisdictions shows that release on secured financial conditions does not assure better rates of appearance, end quote. No study released since then has found anything different. And why would it? After all, if someone misses court, there are already consequences, which typically include a warrant for your arrest and a new criminal charge. So people already have plenty of incentive to come back to court. Adding money on top of that does not, according to the research, impact the outcomes. But what about public safety? Is somebody released on financial conditions less likely to commit a crime than somebody released without those conditions? Again, the answer is pretty straightforward. No. The federal district court in Houston reached the same conclusion about the claim that money bond improves public safety. Quote, the reliable, credible evidence in the record from other jurisdictions shows that release on secured financial conditions does not assure better rates of law-abiding conduct before trial, end quote. Indeed, no credible studies have shown that secured financial conditions reduce the likelihood that someone will be rearrested. Nor do any studies show that higher amounts of financial conditions, as opposed to lower ones, have any effect on arrest rates. And really, why would they? After all, state laws typically require bonds to be forfeited only when you don't return to court, not when you're rearrested. So, the only way financial conditions of release protect public safety is by keeping people in jail. And as we saw earlier, a court cannot do that. A court is not legally allowed to detain someone who's eligible for release under state law by setting a bond that that person cannot afford. One of the most impactful things you can do to improve your pretrial system is to look closely at how your jurisdiction uses financial conditions of release, and think through whether those practices, whatever they are, match up with what the law and research says about the use of money. Start by asking yourself some questions about your system. Do judicial officers rely on a bail schedule to establish financial conditions of release? Are individualized findings made and is ability to pay assessed before a bond is set? Are people in jail because they cannot afford financial conditions? Improving your system starts with examining your current practices, and then charting a path forward towards a system that will be aligned with the law and designed to produce the best outcomes for the entire community.